Hey friends, I've received a lot of inquiries through social media asking advice about filing a malicious prosecution case in California, and that gave me the idea for this short video. Now, a malicious prosecution action is a lawsuit filed by a defendant who just won a prior lawsuit and now wants to sue the person who sued him in a new lawsuit. Got it? Here are tips you need to know before you even think about filing a malicious prosecution action. First, there's a 1-year statute of limitations from when the first lawsuit ended. You want to make sure you file your malicious prosecution action within 1 year of the end of the first lawsuit. Second, you got to win the first lawsuit, and you got to win in a way that's a resounding victory that tends to show you were innocent of the wrongdoing alleged. A technicality like statute of limitations is not a victory on the merits that demonstrates your innocence. Third, you got to prove malice. You have to prove that the person who sued you before in the prior lawsuit had an improper purpose or bore ill will against you. Hard to prove what's inside someone's mind unless you have evidence. And in these kind of cases, sometimes there's an anti-slap motion filed and there's a stay on discovery, and you won't be able to depose the other side. So it's super important before you filed a malicious prosecution action that without discovery, you have all of your evidence that you need to establish malice and what was inside the minds of the people who sued you. Next, you got to prove that the prior lawsuit lacked probable cause. And by that, you got to prove that if you got 100 attorneys in a room, all 100 would agree that no attorney, no reasonable attorney would have filed that prior lawsuit, either because the facts weren't there or the law wasn't there. And if you can't establish probable cause, your malicious prosecution case is dead on arrival. Also, if you want to file a malicious prosecution lawsuit, you can sue the person who sued you, or you can sue their attorneys, or you can sue both. But keep in mind, you have to establish that whoever sued you, whether it's the client or the lawyers or both, that they had malice. Sometimes that's very hard to prove. Also keep in mind that in many instances, the client may argue that they acted under advice of counsel, and oftentimes that affords a complete defense to the person who was the plaintiff who sued you and now is a defendant. So to see how this plays out, suppose Paul plaintiff sues you, you win lawsuit 1, and then you wish to sue Paul plaintiff and his attorney Adam. To win the second lawsuit, you will need to prove that both Paul and Adam acted with malice, and if Paul wants to throw Adam, his attorney, under the bus, Paul could argue that Adam advised him to file the lawsuit, and in most respects that argument would allow Paul to get out of the case. And my last point is, all of the attorney's fees you paid in the first case as a defendant can be recovered as damages in the second lawsuit for malicious prosecution. But all the attorney's fees you pay in the second lawsuit for malicious prosecution are not really recoverable. So if you pay a lawyer $200,000 to prosecute a malicious prosecution action, there's no way to seek reimbursement of those sums. So you want to make sure you have sufficient damages from the first lawsuit, whether it's attorney's fees or emotional distress, to make it all worthwhile. I'm Jeff Lewis, and those are quick tips on filing malicious prosecution actions in California.